Hello, everyone. Welcome, welcome, welcome. Hopefully, we have good volume and you can hear me. In fact, before we get started on anything, if you can just post in the chat if you can hear me okay, so that I can make sure that volume is working. Let me see if we can get perfect. Thank you so much, Jan, Sheila, Christina, Matthew. Thank you so much for letting me know. And then I'm going to also share my slides so that we can make sure we get all the logistics kind of out of the way. I'm Seren Adams, by the way, founding attorney at Adams Law Office. And let me go ahead and share my slides with you. Let's see if we can get this properly on here. Okay, so if in the chat you can then now tell me, oh wow, I got a lot more people telling me volume is good, thank you. If you can also tell me if you can see the slides okay, so that I can make sure I can get started with everything else. I want to make sure both things are good to go. Yes, okay, perfect. And I'm assuming all the new yeses are because you can see the slides okay, which is great. All right, so I'm going to go ahead and get started. I'm sure additional people will be trickling in as we go, but I want to respect everyone's time for being here on time. Thank you so much. And as I said, my name is Seren Adams. I am founding attorney here at Adams Law Office. Congratulations, by the way, for making it here. You're probably here because you've been worried about getting your affairs in order for a while. Something might have happened that pushed this to the forefront, like seeing family or friends go through probate, or you're just worried about putting your family through that same thing. There's also a lot of fear that surrounds this whole topic of estate planning. Sometimes it's fear of the unknown. Sometimes people worry that if they even talk about estate planning, they'll cause something to happen. And sometimes it's just from the realization that your family is at risk and that things are not set up the way you want. So I do want to assure everyone right off the bat, I will not leave you hanging or in that state of fear and concern, uncertain about what to do. I will give you very clear steps on what to do to resolve all of those things. And in fact, knowledge is power. I fill these workshops to the brim with all of the information that you need to know to protect yourself and your family, because getting that information and then acting on it is what gives you peace of mind, and instead of those sleepless nights. So just to let you know what to expect, I'll let you know some information about myself and the firm, and then we're going to dive right into the meat of everything. We start with some basic estate planning terminology and things like that, and then get into some more sophisticated planning techniques using revocable and irrevocable trust. And if you choose to move forward with planning and would like Adams Law Office to prepare your plan, I'll also go over details about our pricing and our process. We don't like to hide the ball at all when it comes to fees. We're very upfront when it comes to what things cost. I think mainly because we know the real cost to your family of putting this kind of stuff off and leaving them without a plan in place to take care of them if anything happens to you and you're not here. So we actually set up our entire process to keep you on track moving forward towards that goal. So let's get started, and I will go to my next slide. Quick housekeeping details in terms of the workbook. You should have the workbook. That should have been emailed to you already. And I can also, yep, I added it to our chat. So you should also be able to get it here. And ideally, if you can download the workbook, print it out, make sure you have a pen handy so that you can write in the workbook any questions that you have that come up as we go. If you didn't get a chance to download and print the workbook, just grab a piece of paper and a pen so that you can jot down any questions that come up as we go. I'm going to save time at the end to answer questions and to make sure everyone has real clarity about what next steps are and about all of the material. So be sure to write down those questions as they come up or post them in the chat, and I will get to them at the end. And to keep track of important things that jump out in this workshop, it's also great to have a pen and paper handy so that as you realize these are things that you're going to need to get in place, specific things you can write down as we go along. I also recommend turning off any distractions so you have this dedicated time to really be able to focus on this material. It's probably brand new material for some of you. Some of you might be familiar with trust or have a trust or have an estate plan already in place, but if not, distractions will help you to miss things. So I recommend turning all things off. Okay, so let's start off with who this workshop is relevant for. This is for you if you don't want to leave a mess, first of all. If you've seen lack of planning play out with family or friends and you've decided in that moment that you did not want that to be your legacy, this is definitely for you. If you've been worrying about this and about how much this is going to cost, what kind of documents do you really need, how long is it going to take to get this taken care of, all of those questions I'll make sure you are clear about, excuse me, by the end of the workshop. If you have legal types of questions, what is probate? What is a trust? What is the difference between a will and a trust? These are the types of questions we hear all the time, and I'll cover these as well. Also, if you have people depending on you, even if your kids are grown or you don't even have kids, you still care about how your assets will be handled. So something I've come to understand over the years of doing estate planning for over 20 years now is that a lot of estate planning is not actually about you. It's about the people that you love, and whether they're dependent on you or not, it's still important to make sure that planning is in place for them. It's really about making sure that you're protecting them from any kind of unnecessary drama or expense or heartache. And there's actually a place in your workbook where you can write down the people that you are planning for, the people who are coming to mind as I talk about this, and the people that you want to protect. It's helpful to keep them in mind as we go through the material. So the people that I love the most and why I ended up doing estate planning, quick introduction about me. This is my family. I've been practicing in the estate planning area for almost 25 years now. Graduated from George Washington University Law School in DC and was recruited to Ernst & Young right out of law school to their national tax department, where I was basically helping big companies avoid taxes. I immediately felt like I was in the wrong area of law. But I was initially introduced to estate planning because my family had me prepare their estate plans. My very organized sister, in fact, actually prepared her own estate plan before I even went to law school, and had me witnessing things, signing off on things in her plan. I was very impressed with her. And then I actually took an estate planning class in law school and realized that what we had signed was an absolute mess. It would have been thrown out by a probate court. Every other week in class, I was learning another new issue with her documents, because when you're self-preparing things, as impressed as I was at how organized she was and seemed like she had this all together at the time, you just don't know what you don't know. So right after graduation from law school, of course, she had me redo her documents as if I was now big-time expert in the field, which I was not. Right out of law school, I was using the form documents that the Bar Association gives attorneys to use for traditional estate planning, what most lawyers use. The problem with those documents is that they lead you right into probate court, the same situation we would have been in with her mess of documents. That was not what my family wanted. A couple of years later, I then had my son, and we prepared my own estate plan. And that's when I really got hyper-focused on this area of law. I remember going out of town for the first time without my son, out of the country, actually. My husband and I flew out of the country. My son was about 2 years old. I broke out in hives for the first 3 days of that trip because I was worrying about all the things that our plan was not going to cover. So that traditional estate planning really had me shift what I was doing. I left Ernst & Young, started my own firm, with the goal of finding a better way than the traditional estate planning that would make sure that we're keeping people out of court, families out of conflict. So as the firm started growing, I started meeting these awesome ladies who had very similar experiences with their careers in terms of not liking the path that they had ended up on after law school, and searching for kind of real meaning in what they did. And these are our associate attorneys and I truly feel blessed that these ladies have linked arms with me and joined the vision of the firm of serving families by making sure that legacies are preserved and not lost, and that each generation is not starting from scratch. They're really dedicated to that and to making a difference in that way. And they're awesome also at explaining complex things, communicating that really well in easy to understand terms. So that is also a real blessing in terms of their ability with clients to kind of get this narrowed down to what is really going on. And then we have our support team. We are a wonderful group. One of the things I really look for when I'm looking for team members is a passion for people and a passion for serving others. And that is truly what I can say about each and every team member. Such a blessing to have this group of people together. We really enjoy how much of a difference we get to make in the lives of the families that we serve. I would say, except for Lola, our office puppy. She's not necessarily that friendly or passionate about people, but we love her nonetheless. But that is really the true blessing with working with this group of people. And along the way, we've received a few accolades, which is great when you get that from doing something you love anyway. So that is a little about us so that you know who you're hearing from. And now let's get into some of the content. Let's start really by talking about your current plan. So even if you signed up for this workshop because you are like most Americans, 55 to 67% to be exact, of Americans that have no estate plan in place, no will, no trust, no power of attorney, no medical directives, you actually still do have an estate plan. It's the state's estate plan. The state has a plan for you. State of Maryland, the District of Columbia, whichever state you live in, the government has a plan for you, and that's called the intestacy laws. If you pass away without any kind of estate plan and nothing you have put in place that's legally binding, the intestacy laws kick in automatically. And what's even worse is that if you have an estate plan, like my sister's plan that was a hot mess, if it has legal issues or anything like that going on, and usually that you're not even aware of, the court can actually throw out your plan and use the intestacy laws instead. So I had a case like this last fall where this exact thing happened. My client's father had drafted his own will, and well, at least I hope he was the one who drafted it and not an attorney, because it was a hot mess. But the sad part was it was very clear what he was trying to accomplish. He wrote 2 separate wills to address 2 separate properties that he owned because he wanted each property to go to specific children. 2 children with one property, 3 children with another property. Unfortunately, that's not how you do that. And the probate judge threw out both wills and applied the intestacy laws instead, which was the opposite of what he wanted in terms of how things were distributed. So most people have assumptions about what's going to happen if they pass away, but it's really important to know what the reality is, because most of the time it's different than what you would have wanted. For example, most couples assume that if something happened to one of them, the other one would inherit everything. But under Maryland law, that is not what always happens. For example, if you are married with minor children, meaning that your children are under 18, then your spouse gets half of your estate and your minor kids get the other half. And that's usually not at all what most couples are planning to do. What it actually means in that scenario with the minor kids getting half is that the court is going to have to get involved in assigning a guardian of those minor kids' property. If the court ends up picking a third party, they can charge fees on a monthly basis sometimes just to be looking at a bank account. So less money ends up going to your kids. And what's even worse is that when your children turn 18, they will inherit whatever's left in that account without any supervision, because they'll be considered an adult at 18. If you think back to when you were 18, that's usually not a great time to inherit a lump sum of money. Usually means your friends or social media are going to control what happens with those funds. Even the most responsible 18-year-old, after the pressure and issues of losing a parent, are not making great decisions. So another example of intestacy laws, if you're married with adult children and your spouse passes away and had kids that aren't your biological kids, like tons of blended families, you would get a spousal allowance and half of the estate, and the kids get the other half. Again, usually not what families are intending. If you have no living heirs or stepchildren, the Board of Education gets your assets. So clearly we can make a better plan than the state's estate plan. Ideally, your plan gets you really financially organized. Organization is one of my favorite things. I'm one of those crazy people who love lists, love organizing closets with like the type and the length and the color and all of that stuff I find very fun. But financial organization is making sure that you have a complete and up-to-date list of all of your assets. You also want to be sure that list is accessible for your loved ones if something happens to you, so that those assets are not lost. There's over $1.6 billion right now in Maryland's unclaimed property accounts. Every state has one of these, so billions of dollars across the country. You certainly do not want any of your hard-earned money ending up there. Your plan should also reflect your wishes. So if you don't want some creditor or your child's ex to eventually inherit your hard-earned assets, you need to make sure that your plan has specific protections in place. And you can also protect your loved ones from themselves, like from wasting assets to stronger asset protection techniques that are available if you actually do planning to keep what you're leaving them from ending up in the hands of creditors or predators. All of that actually protects your assets in the long run, but a good estate plan can also make sure that things are in place if you become incapacitated. So to make sure that the right person can step in and take care of you and your affairs instead of having a random judge appoint a guardian over you and your property. Ultimately, you want to be able to build generational wealth and a legacy of caring and guidance and organization and peace, rather than leaving that mess. On the opposite end of the spectrum is the state's estate plan for you, which is basically going to court, and that's the state's plan. If you don't have the documents in place or the documents are wrong and you become incapacitated, you basically think of this as if you were this scenario happening. If you're driving down the Beltway, you get into a horrible car accident, or if you have a major stroke and you're in the hospital for weeks and then rehab for who knows how long, and you can't take care of yourself. In that kind of scenario, the state's solution for that is guardianship. And that's where a random judge picks someone to take over your finances and make medical decisions for you. And that is as scary as that sounds if the wrong person gets appointed. If you pass away without the proper documents in place, or you just have a will, the state's solution is probate. So the middle part of what I just said is worth repeating because it's one of the biggest myths about estate planning, which is that a will is sufficient for estate planning. If you just have a will, your estate has to go through probate. It's how a will gets administered, actually. It has to go through that probate process. So probate is basically, I describe it as something like you're basically suing yourself after you have passed away for the benefit of your creditors. So the primary issue, and there are several issues with probate. One of the primary ones, though, is that administrative burden on your family members. There are very specific documents containing all sorts of information that have to be submitted to the court by certain deadlines, all of this happening when they have just lost a significant loved one. So it's very burdensome. It's also costly. In Maryland, the costs are actually capped at 3.6% of the estate size. DC has no cap. Many states don't. But for example, let's say you just have a house. That's all the only asset. A house worth $500,000. You have no bank accounts, no investments, no personal property. The cost for that $500,000 estate would be about $20,000. That's 4 times more than the cost of a good estate plan. Probate also causes a delay in distributions, 7 months to a year for a regular estate in Maryland, about that long and a little longer in DC. The national average is 18 months. Probate's also public. So predatory individuals can easily find out, anyone can easily find out who is inheriting from the estate, their contact information, how much they're inheriting, and when. So leaves your family up to things that you can really avoid and not want them subjected to in that situation when they're already under the pressure of loss. So probate, especially intestacy probate, the kind where the state law rather than you is deciding who gets what, can be completely avoided with the proper estate plan. So our goal really with estate planning is to avoid what we call modern day grave robbers. Those would be things like probate, also mismanagement of your property, family drama. We definitely want to avoid that. We also want to avoid things like running out of money. One of the major ways we see this happening a lot lately is because of the high cost of long-term care. Long-term care cost can cause the loss of a family home due to Medicaid liens, or the flat out sale of a family home just to pay the cost of care. Just spoke with someone day before yesterday about this. They're planning on selling the family home to keep the person that is disabled in a facility. So spending on these things, or the spend down of assets just to qualify for Medicaid to pay for long-term care. We bring this up in our estate planning consultations because long-term care costs can quickly derail an estate plan that we have prepared beautifully, or any kind of financial plan if you haven't properly planned for this. So let's take a look at this. Most studies are consistent in showing that 1 in 2 people, so half of the American population, will need some sort of long-term care. Alzheimer's is growing at a really alarming rate. There's over 55 million people worldwide who are suffering from Alzheimer's, over 7 million in the US. Studies are also showing that people are living as long as 20 years after diagnosis of Alzheimer's dementia. So a really long time to be living with the disease. And another thing that's been coming up is that caregivers are at a really high risk of developing their own health problems or worsening existing health issues because of the stress of caregiving. So all sorts of issues developing, and the cost is the biggest issue though. The average cost of nursing home care, and this is coming right from Medicaid's numbers. This is what Medicaid says the average cost of care is in Maryland, $12,500 per month. It's even worse in DC. It's something like $14,000 per month. That's over $150,000 per year. You might say, well, I'll never end up in a nursing home. I'm going to be cared for at home with my family. But usually in that scenario, some sort of private care is needed for healthcare issues, or if the person is working, that is your primary caregiver. Private care is very costly. I have my mom who's living with me. We just looked into this last year. It's very expensive. The average hourly rate for home health aides is $29 per hour. That's about $60,000 for just 8 hours a day while you're at work. If you're doing full-time, like if you have somebody who has memory issues and so forth, wandering and so forth, and you need 24-hour care, that's over $250,000. So how can most families pay for these kinds of crazy costs? Payment options include things like Medicare, but Medicare will only pay for the first 100 days of long-term care after a hospital stay. It's not the source that you're supposed to be using for long-term care. It doesn't pay other than the scenario, 100 days after a long-term care hospital stay. Medicaid is the other option. And that is the source that you're supposed to use for long-term care, but you have to qualify for Medicaid to pay for your long-term care. In Maryland, you have to have $2,500 or less in assets in order to qualify for long-term care. So I'm sorry, to qualify for Medicaid. So basically have to be dirt poor and really, really sick. One of the other options is to use your savings. Not a great option because you usually have to use it all up on the nursing home. Another option is to purchase long-term care insurance. That's one of the options we discuss with many families. If they're young enough and fit enough, able enough to get long-term care insurance, that is a great option. Another option is implementing a legal plan that's going to protect your home, protect your savings. We'll look at that in a little bit. A combination of all of these things, though, is usually what ends up happening, because most of the time when families are looking at needing this, they're using any available method that's available to help. But before we talk about the legal plan you can use to protect from these long-term care costs and from guardianship and from probate, let's look at some of the DIY methods that can be used for planning and why we want to end up with the recommended method, which is a trust. So here are the ways you can avoid at least probate. We have joint tenancy ownership, beneficiary designations, or by transferring assets to a trust. So there are pros for all of these options, but the first two options are what I call the DIY options, which also have some major cons associated with them. That's why trusts are actually the recommended way of avoiding probate, as well as all of the other modern day grave robbers. Most people are familiar, we'll go through each of these. Most people are familiar with joint tenancy through owning things like real estate or cars jointly with somebody. If one owner dies, the other person inherits that property automatically. The property does not have to go through probate to be distributed to the other owner. It happens automatically by contract law. That is the pro. The issue with this type of ownership is when that last owner passes away. In order for that asset to go to anyone else, it has to go through probate. Even if that last person's will stated where they wanted it to go, it still eventually has to go through probate to get to anyone else after that last owner passes away. So this method does not eliminate probate, it just delays it. The other option, beneficiary designations. Most people are also familiar with beneficiary designations on things like life insurance, IRAs, bank accounts, even real estate now. After the owner of the asset passes away, the asset goes directly to the beneficiary without going through probate, again, through contract law, and that is the pro. The issues or the cons, and there are quite a few issues with beneficiary designations that we'll go over. Number one, if the beneficiary designation is simply not kept up to date. So like having a parent listed instead of a spouse, someone you no longer want to inherit, like an ex. We see this at least a few times every year where someone comes into the office and they have not updated things, and the person sitting right next to them is expecting that they're the beneficiary, but it's somebody else, like a mom or a dad or something like that. Happens very often. Another risk is if the beneficiary is no longer alive. What if that beneficiary you've named passes away before you? That means that life insurance proceeds, whatever has the beneficiary designation on it, would have to still go through probate to get distributed to anyone else. Another issue, if the beneficiary is a minor, this happens all the time. Families will list their spouse and then their minor children as the backup beneficiary on policies, IRAs, bank accounts. If the person is incapacitated, this is an issue. If the person is irresponsible, it's an issue. If the person is a minor, it's an issue. With minors, those assets go into a custodial account, and that beneficiary, again, same issue we were talking about before, will receive it at 18 because they'll be considered an adult. So they inherit the full asset with no supervision, and most likely it will get wasted. If the beneficiary you've named is incapacitated, meaning they're disabled, they're receiving some sort of state or federal aid, they would lose those benefits after getting an inheritance in a lump sum like that, because those benefits are yet generally means-based or needs-based. That's a very dangerous situation to put someone in, because they have to then use up all of the assets that you've left them, which most likely will not last their entire life. And then they have to reapply for the benefits they were receiving before, but after they've used up all of the assets you left them. So there'll be this time period where they're destitute, essentially waiting to get reapproved. So very dangerous situation to put someone in. If the beneficiary you've named is irresponsible, that's another issue. The proceeds, again, are likely wasted on bad decisions, bad habits. This is also why it doesn't even address the guardianship issues, the long-term care expenses. It definitely doesn't address family drama or mismanagement of assets or asset protection. So all of these options that we're talking about, joint ownership, beneficiary designations, they skip all of the other things that we need to be addressing in estate planning. The guardianship issue, the long-term care issue, family drama issues, mismanagement of assets, and asset protection. This is why the recommended way to avoid probate, as well as all of those other issues, is through a trust estate plan. The other things that you should have in your estate plan, some of which, by the way, are never addressed in traditional firms or with traditional estate planning, but let's look at each of these. First would be record of tangible and intangible assets. We'll go through each of these as well, so you understand what you need. Guardianship designations for minor kids, durable power of attorney, an advanced healthcare directive with a living will and separate HIPAA authorization, and an organ donation addendum if you want to be an organ donor, a last will and testament, and a family trust, which is what we would call a revocable trust, or a legacy trust, which is an irrevocable trust. So let's start with looking at each of these things that you would need in your good estate plan. The first would be that record of tangible and intangible assets. We actually start our process with having you create that inventory of your assets. So you're able to get financially organized, and at a minimum, you'll be making sure that your family knows where your assets are and things are not going to get lost to unclaimed funds. This is actually something you can do on your own as well. It's a great place to start when doing estate planning, making that list of all of your accounts, bank accounts, life insurance, retirement accounts, investments, and what financial institution is holding those assets so they are not lost. Again, there's $1.6 billion in Maryland's unclaimed property accounts. It's where money goes to die. The final step of our process is what we call our legacy interview. So we kind of bookend the tangible and intangible assets in our process. The legacy interview is where you record your values, your family stories, the things about you that make you you, the things you want to pass on to the next generation. Really creating a legacy for the next generation. And these are also things that you want to record because you don't want these things lost either, just like the financial assets. Another thing you need in a good estate plan is guardianship designations for minor kids. This is a hugely important issue. This is the thing that broke me out in hives on vacation, is all of these things that can come up that aren't addressed in traditional estate planning. So if you have minor kids under 18, or grandkids under 18, this topic is super important and completely overlooked in most estate plans. Think of it this way. There are two scenarios. What happens if you just simply don't make it home? If you're on date night, if you're at work, traveling back home, again, you're on the Beltway, something happens. If your kids are at home with either a babysitter or they're home alone and police arrive, they actually cannot let your kids, if they're minors, just stay in the home alone. They have to put them into protective services. And to me, 5 minutes in protective services is 5 minutes too long. Most estate plans will designate a guardian for minor kids in a will. But as we talked about, a will has to go through probate. Getting in front of a probate judge takes weeks to do. In Prince George's County, it's taking months to do. One of the issues is once your kids are in the system, your family getting them out of the system is not easily accomplished unless they have the proper documents in place. What happens also if you get into that kind of car accident and you have not passed away? You're just in a coma, you're unconscious, you're injured in some way, but you have not passed away. Your will only governs what happens after your death. So there's nothing then in place to say what happens and who's supposed to be in charge of your children. We've addressed this major gap in estate planning with what we call our kids protection plan, where you designate guardians for your children and create a process or a flow information of all of the things that they would need to be able to take care of your children if something actually happened to you, and prevent your children from being placed into protective services or with the wrong family member or friend. We call, again, our kids protection plan, and we put this in place for every person that we serve who has minor children to make sure that this gap is filled. The durable power of attorney is another thing you need to have in place. This names an agent that handles your financial decisions if you become incapacitated. So things like collecting your mail, paying your bills, paying your mortgage, filing your taxes, taking care of your pets even. If you don't have this kind of document in place, what you're really asking is for your friends and family members, because usually somebody will step up and take care of these things for you, but you're asking them to act illegally, commit mail fraud, bank fraud, forgery, and just to be able to get your bills paid. You do not want to put someone in that kind of situation. And by the way, it's really important for single individuals, if you don't have adult children, to have an estate plan in place, because there's no default person that the court is going to be able to appoint to these roles. So you don't know who's going to be appointed, and it could be the wrong person. So you need to be really sure that you're specifying who you want to handle your affairs so that the wrong person does not get appointed. A durable power of attorney is durable because it survives your incapacity, but it does not survive your death. You would still need a will or a trust to govern what happens after you pass away. You also need to have an advanced healthcare directive. This names an agent that handles your medical decisions if you become incapacitated. You should also have what is called a HIPAA authorization, so that agents can gain access to medical records even if there is a medical malpractice that causes your death. This extends beyond the normal expiration of these documents and the power of attorney to 2 years beyond that, so they can gain access to those records. You also want to make sure you have a living will in place, which states what your end of life wishes would be. So your family and friends are not guessing, calling a vote, all of these things that we hear about, and then worrying later that they made the wrong decision. If you're incapacitated, you have a terminal condition, end stage condition, any of these things, vegetative state, you can name how you want that to end and whether you want to be on life support for a long period of time, whether you don't, what the time period is, all of the details. You can also include an organ donation addendum if you want to be an organ donor. But all of these documents in the medical directives, we really saw the need for this during the pandemic when people were admitted to the hospital, they were intubated so they couldn't speak, other family members were not allowed in the hospital. So if you didn't have this kind of documentation, it was very difficult to get information about what was going on, very scary for families. So having this in place is very important. As soon as you turn 18, having the advanced healthcare directive and the durable power of attorney, very important to have in place, because any parents out there who have kids over 18 know that as soon as that happens, you lose access to everything, even though you're paying the bills. Anyway, the last will and testament is an additional document that you should have in place. Again, not the only document that you should have in place, or not the governing document that you should have in place. It names who gets what, who handles the distribution of your assets, but it handles it through probate. So if you have children that are still minors, this is one reason that we still prepare a will, because it does name the guardian officially after you've passed away, who would be in charge of your kids after that probate process has been initiated. You would also state what your burial or cremation wishes are in your will. But it's really important to know that a will does not prevent your estate from going through probate. It requires it to go through probate. It just makes sure that your wishes, rather than the state's law, control what will happen in your estate. And that's if your will is properly prepared, because it could also be thrown out. The trust is what prevents your estate from going through probate. So let's get into trust and how they work in a recommended estate plan to prevent the issues that we just spoke about, like probate, guardianship, intestacy laws, so that we can know what this document actually is. So a trust is created through a legal document called a trust agreement. What you're essentially doing when you create a trust is you're basically creating a separate legal entity apart from yourself, similar to creating an LLC or a corporation. And you use this entity or the trust to manage your assets during your life for your benefit, just like you're doing now, and then to efficiently distribute those assets after your death with much more specificity and protection for your beneficiaries and for you. A trust can either be revocable or irrevocable. And whether it's revocable or irrevocable, it has certain parties or people involved in making it work. Those people are going to be the grantor or settler, same thing. And that's going to be you. That's the person who creates the trust. And then you're going to have a trustee, and that's the person who manages the trust and the trust assets. Think of that like the CEO of a corporation. In a revocable trust, that's also going to be you. The trustee can sell, they can refinance anything that you could do with property before you put it into the trust. When you put it into the trust of a revocable trust, if it's properly drafted, you're able to do all of those same things as trustee. The trust is also going to have successor trustees, at least one. And that successor trustee, that's the person who's going to step into the shoes of the initial trustee after they have either died or become incapacitated. Then you're also going to have beneficiaries. That's the final party to the trust agreement. The beneficiaries are the people who receive the benefit of the trust assets. In a revocable trust, that's also going to be you. You have the benefit and get the benefit of the property while you are alive. You live in your house, you take money out of your accounts, you take money out of your investment accounts, any of those things. You also would name, though, beneficiaries for your assets after you pass away, like your kids, charities, whomever you choose and how you choose, which is one of the biggest differences between a trust and a will, is that how can be really, really specific. One of the big things to know about trust is it literally is just a stack of paper, stack of expensive paper, unless the trust is actually funded with your assets. The trust is funded by retitling or assigning assets into the name of the trust. This is key and one of the main things you need to be looking for when you're getting a trust plan. You want to make sure that your attorney is going to be helping you with this crucial part. We see so many couples and individuals, families that come to us with trust plans that they've gotten created that was never funded. So it's not doing anything. Their estate would literally go through probate because nothing has been put into the trust. So one of the big things that we make sure is funding as much as we can of your assets on our own so we can make sure it gets done. We'll mail out anything that can be mailed out. We prepare the deed and get that recorded and give you instructions for any things that you have to do. Like if you have to do something online or go in person to a bank, we'll give you complete instructions and follow up with you to make sure that you actually get it done. Because this is the biggest piece of getting a trust plan other than getting the trust, is making sure it is funded. I also make sure I stop here and talk about if you're thinking about doing a trust on your own. Estate planning, well, I had the experience with my sister to, first of all, scare me from doing that ever or recommending that ever. But doing a trust plan without an attorney is a really dangerous thing to do because of funding. You actually have to transfer your assets into the name of this legal document. And so think of transferring your house, your bank accounts, investment accounts into the name of something you're not sure if it works, or you're not sure if you did it correctly. You could have dotted every I, crossed every T, and just don't know what you don't know. And you could have just created a bigger mess for your family than you solved. We get cases like that all the time. Those are our probate cases where someone has either tried something online or from some source and Staples, wherever they got these documents, Susie Orman, all of these things where you try to do this on your own. And again, you don't know what you don't know. And funding something into that type of document, again, is really dangerous. You want to make sure that this is done correctly and that you have all of the things taken care of, every I dotted, every T crossed. It's not the kind of thing that you should try to cut corners with. And even if you don't choose Adam's Law Office to get this done, I recommend getting a professional who specializes in trust planning and estate planning to make sure that this is done properly. Okay, off of my soapbox. So one of the best ways to think about revocable versus irrevocable trust is to think of a treasure chest. What we call our family trust is a revocable trust. It's an open chest. Think of it as an open treasure chest without a lock. You're the grantor, you're the trustee, you're the beneficiary. You have complete control over it. You can put assets into the trust, take assets out of the trust anytime you want. You're in control. All of those assets that you put inside of the trust, because you have complete control over it, if a creditor or a court allows a creditor to get a judgment against you, say you didn't pay American Express, they now have a judgment, a judge can force you to go into your trust to get payment for that creditor because you have complete control and access to it. It's not an asset protection tool. It's an estate planning tool, which it is really good at doing because everything you put inside of the revocable trust, the probate court is going to completely ignore. None of these assets will go through probate, which is a huge benefit. The legacy trust, think of the legacy trust as an irrevocable trust that is a locked chest. So with the legacy trust, you're going to be putting your assets inside of that as well. You can put your house inside of it and still live in your house. You can put your bank accounts inside of it, investment accounts, all of those things, beneficiary designations to life insurance, and all of those things inside of the trust. But you're going to be closing that trust, that treasure chest. You're going to lock it, and you're going to be giving the key to somebody else, a separate trustee, like an adult child. That property you can't reach back in and take out. Once you've closed that lid and locked it and given the key to somebody else, you don't have control over that asset anymore. You're not the trustee of it. In the ideal scenario of these types of trusts, you're not the trustee of it, because we use a lot of these for Medicaid, which has very specific rules. But you can name a beneficiary other than yourself, like that adult child, who can receive property from the trustee in case you have needs that arise. But you don't have the direct control and access of that property once you put it in. The big benefit of that is that, again, probate courts completely ignore what's inside of that trust. Even bigger benefit, Medicaid, after the 5-year look back, will completely ignore anything that you've put inside of this trust. So it can look as if you have $2,500 or less in assets, and Medicaid can pay for your long-term care instead of you spending down all of the assets or getting liens placed on homes that you put inside of the trust. All of it is protected, and Medicaid can then pay for your long-term care. So it's a huge tool that we use a lot if you're concerned about long-term care cost or Medicaid spend down, all of those issues, and you can no longer qualify for long-term care insurance. Irrevocable trusts are a great option for that. They're also a great tool for asset protection from creditors. I mentioned how a judge, if you are in a revocable trust scenario, a judge can force you to reach into that trust to pay the creditor because you have complete control. With the irrevocable trust, you've given the key to somebody else. So a creditor can say to you, reach in and get something to pay me, and a judge can tell you that as well, but you don't have direct access to it any longer. So they don't have any control over the person you've given the key to. So it's a perfect tool used for asset protection because of that. These techniques can be used in land trust to hold primary residence or investment properties along with LLC structures. They can be used as privacy trust so that people who may be trying to sue you or to get to property, if you put it in there well in advance of any kind of lawsuit, it can protect against that, so that they can't even tell that you actually own those assets. It can also be used with things like offshore trust. That's the best asset protection tool to keep assets out of reach of potential lawsuits or creditors. Irrevocable trust can also be used to reduce your estate size so that it can eliminate and minimize estate taxes. That's not a concern for most families currently because the estate tax threshold or the exemption rate is so high right now. $15 million for the 40% federal estate tax and $5 million for the 16% Maryland and DC estate taxes. That means if your estate is below $5 million and in Maryland or in DC, you're not subject to the 16% Maryland or DC estate tax. If your estate is below the 15 million, you're not subject to the federal estate tax. So part of the decision about whether you're going to be using this kind of higher level planning technique, the irrevocable trust and so forth, depend on cost, number one, and what your budget may be for planning, because irrevocable trust planning can be much more expensive than revocable trust plans. The other issue for Medicaid type of irrevocable trust, another consideration is, again, whether you have or you can qualify for long-term care insurance. If you don't have that type of insurance or you can't qualify for it, or it's cost prohibitive, this type of trust can protect your assets from those long-term care costs. And another consideration that you would use with evaluating whether you would use this kind of planning is how much of your property you want to protect from creditors, lawsuits, or estate taxes. So if those are concerns, that type of plan is available. So as far as the benefits of trust in general, whether they are revocable, irrevocable, there are a bunch of them. Avoiding probate is the primary one. The biggest reason most families use trust plans at all is to avoid the hassle I talked about earlier, time, delay, cost, administrative burden, all of those issues, the public aspect of it. all of those issues that come with probate can save tens of thousands of dollars for most families by simply using a trust plan, plus the saving of the time and the elimination of that frustration and anxiety of dealing with the court system after the loss of somebody. With a trust, you can also be really detailed and creative about how to handle assets based on different family situations. It's actually why I love trust planning, is how creative you can be. If you have younger or maybe less responsible beneficiaries, whether that's your kids or even if you don't have kids, but you're leaving assets to nieces or nephews or godchildren, you can hold assets in trust and distribute them over time so that you avoid the issues that can happen when you just have a will or you just do a payable on death beneficiary designation on accounts or things like that without any structure or guidance. And then that young person inherits a chunk of money at 18 after the loss of someone important in their lives. And they're very vulnerable at that point to the whims of their peers and social media for decision making. So eliminating all of that, instead, you can have the trustee that you select hold assets in trust and distribute for their needs like healthcare, education, living expenses, all of those things. And then at certain ages, give them those lump sums over time. And you get to choose what ages, what percentages, when those distributions happen. What a lot of families do is a third distribution at 25, a third at 30, and then a third at 35. But again, you can choose whatever ages you want, whatever percentages you want. You can even be very specific with purposes that they can use funds for: higher education, purchasing a home, starting a business, investing. So it can really be focused on your specific legacy priorities as well. I have some clients who are very much into entrepreneurship. So they'll put provisions in about having a business. If you have a business plan that you submit to the trustee, you can get a distribution earlier than the ages that they've specified to encourage that kind of thing in their family members. You can also require that beneficiaries do things like take financial management courses or speak with a financial advisor before receiving a lump sum distribution if you don't think they'll have the financial savvy to be able to take care of things once they get those lump sums. You can even require, if you have beneficiaries who are irresponsible or have bad habits, drug issues, alcohol issues, unlike the beneficiary designation scenario, you can require things in a trust where you can say they have to pass drug tests before they get a distribution. Had a client in this exact scenario where her sister was her only beneficiary, and her sister was actually in rehab at the time that we were preparing the estate plan. So we essentially set up this whole method where her sister had to pass 3 successive drug tests to get any distribution at all. The distribution started very small and went up each month if her sister continued to pass drug tests each month. If she failed a drug test, the amount went down to the low amount that it started at. And if she failed successive drug tests, it stopped. She had to pass the 3 drug tests again to get distribution. So all of that language and description and requirements really can incentivize the behavior that you're trying to encourage. So really creative things can happen. A trust can also work as an asset protection tool for your adult beneficiaries. So say you have adult children or just adult whomever that you are leaving assets to, and that beneficiary is going through a divorce at the time they're due to inherit from your estate, or they have a tax issue, or they're being sued by somebody. Say they got into a car accident and insurance is not covering it, and now they have $1 million lawsuit that's pending. They can choose to leave your distribution to them, the inheritance you're leaving to them. They can choose to leave that in the trust that you have left and make smaller distributions to themselves, maybe monthly distributions of a smaller amount that are exempt from creditors, or yearly distributions, or just wait until the situation is passed, like a divorce, before they get any kind of distribution from your estate plan. So you can build that kind of planning into your trust as well, that asset protection for your beneficiaries. If you're married and you pass away and then your spouse chooses to remarry, you can also add in protections against assets being taken by a new spouse or being distributed to someone other than your children. I call it the Cinderella syndrome, where somebody you don't even want to be inheriting ends up taking everything, like the kids of a new marriage. You can actually require that your spouse, if they remarry, that they get a prenuptial agreement in place to protect the assets that you've left for your specific children. It keeps assets into the name and out of the name and control of the new spouse. And your spouse can just blame your trust for having to get that prenuptial agreement. Also, because you're avoiding probate and being really specific with the distributions, a trust administration after your death doesn't have to be administered by an attorney, and it can take as little as a day. It's much less costly. One of the big benefits of working with our firm, for example, we're very committed to working with clients for a lifetime and making sure that their family is served as well if they need assistance if something happens. We have internal systems, contingencies to make that happen. So if your family wants help, they can have it. But your trust is also built for them to be able to handle things on their own if they want to. So we build those instructions and all of those things in so that it can be a self-sufficient plan. Another benefit of a trust is that if you have real estate in multiple states, transferring ownership of those properties into the name of the trust will prevent probate in each of those multiple jurisdictions. So again, a huge cost savings and savings from having to hire lawyers in each of those states to serve as resident agent and of the estate and to administer the separate estates in each of those states. All of that eliminated all of the cost of each of those separate probates. One of the other huge benefits, we talked about guardianship earlier. If you're incapacitated during life, your successor trustee that you name in your trust can step into your shoes and manage your assets while you're alive. It prevents that entire guardianship proceeding from needing to happen at all, because you've given instructions in your trust plan for what to do with your assets, and that is to take care of you, and given your trustee the ability to do that through that legal document. I really love trust planning, by the way, if you have not noticed, because of how creative you can be and how many issues that it really can solve. So I shared a lot of information and some stories about the estate planning that went wrong. Mine and my sister's first plans that would have ended up in probate court, at least hers in probate court. My client's father, whose DIY will was thrown out of probate court. Hopefully what you see, unfortunately, the typical documents in traditional estate planning or DIY plans leave your family at risk. I imagine you're here in this workshop in the first place because you don't want your family going through unnecessary expense and time and being in court, having assets lost to unclaimed funds, or leaving your kids at risk. You want to leave a legacy instead of a mess, the name of my book. And that is our main goal, making sure that families are able to leave that legacy instead of a mess. Your mind is probably swirling as at this point of the workshop, usually with all of this information, really thinking, what do you need to do for your actual family? How does it apply to your actual family and your specific assets? And even how much is this going to cost? So all of those question marks are exactly why we start our process with the legacy planning session, so that you can get really clear on exactly how your specific family situation lines up with the law. What would happen if your family, if something happened to you, and what you would need to do to protect your family. We answer all of those questions, and it really depends on your family dynamics. Every family is different. There's no one size fits all estate plan. It depends on your family. It depends on your assets. It depends on how the law applies to your specific situation. So the way we identify all of those things, figure out all of those things for each person, is taking you through that legacy planning session. The legacy planning session is a 90-minute working session with the attorney where you go over your specific situation. You get your questions answered, apply the law to your family's facts, and look at what would happen if something happened to you. We then figure out what about that scenario doesn't work for you or does work for you. And then from there together, choose what plan will help to address those issues. And from a cost perspective and an outcome perspective, making sure that you're able to preserve your family legacy. So the legacy planning session is normally $750. But I'll let you know in a little bit how you can get that session for free. plus an additional $250 off of any planning you might choose to do with us. We have 3 main estate plan packages, though. The packages range from $2,500 to $7,500, just depending on your family dynamics and your goals, what things you're trying to accomplish in your estate plan. The most important thing about our fees, though, is that you choose your fee. You choose where you fall in that range during your legacy planning session, depending on your goals and what you're wanting to accomplish with your plan. And you make that financial investment in that meeting in securing your estate plan to protect your family and your family's future. So really, this type of planning, you have to weigh the upfront financial investment versus the ultimate cost to your family of having no plan in place, which is typically going to cost them a lot more financially, not to mention the time and the stress as well. By the end of your legacy planning session, that deep dive into your family's dynamics and goals, you have the confidence of clarity, knowing that you're making the best decision for yourself and for your family based on the facts of the situation, and only making an investment in an estate plan that is going to save your family money. Also achieve your goals and save your family time and that stress as well. So where do you start? Preparing a list of your assets and getting recent account statements. Again, gathering that list of assets is a great place to start with estate planning. That is part of our questionnaire process, so you can be financially organized even before coming into the planning session, like we mentioned before. And that kind of thing you already need to do because you already need to make sure your assets are not going to get put into unclaimed funds. All of the hard work that you do to acquire things, you do not want it just eliminated and sitting there in unclaimed funds until it gets distributed to the state. Second thing to do is decide who you want in important roles and gathering their contact information. So who you want as your power of attorney, who you want as your successor trustee. A little hint is if you think about who you want in those important roles ahead of time and have their contact information with you when you start your questionnaire, you honestly can finish that questionnaire in about 15 minutes. It's very fast when you have things right in front of you to be able to plug those things in. Third thing to do is to think about how you want your beneficiaries to receive what you leave them or any kind of special instructions that you want to leave. And that legacy portion as well, how you would want to build in your legacy, the thing that you want to make sure you're remembered for, or the things that are important to you, how you want to build that into your plan. So the fourth thing would then be scheduling your complimentary legacy planning session. So the legacy planning session is the right fit for you at this point, this juncture in life, if you're ready to get your affairs in order. Also, if you're ready to set up a plan that's going to secure your future and protect your family and ready to invest in getting that plan in place. Our process to get your plan in place typically takes 4 weeks, starting with that working session with the attorney. You can get the legacy planning session, get to the legacy planning session or do the legacy planning session in our Bowie office, or you can do it via Zoom, which most of our clients choose to do. It's really convenient, but either scenario works. At your planning session, we hit the ground running. We go over all of your questions, your family situation, your goals, what your current situation looks like for your loved ones if anything happened to you. And we then identify some solutions to address any issues we find with the current situation. So then you choose your desired estate plan to fix those issues that we've identified. After you choose the plan that fits your budget and your needs the best, you pay for your plan. And then we start designing your plan. Together in that legacy planning session, that design session is something that we do so that you're involved in how this plan works. And all of those things that you thought of ahead of time in terms of how you want your legacy impacted, how you want things distributed, that gets incorporated into your plan. After the legacy planning session, during those first couple of weeks, we then prepare your plan and send you drafts to review, which is also something that is really important to make sure is happening. In about 4 weeks from the planning session, we then meet again at your signing ceremony. which can also be by video conference, by the way, if it needs to be. And this is where your plan legally gets put in place. This is a big day. You toast to champagne if you want to on that day, because it is a celebration of something that you have accomplished. It is huge. Everything that you've expressed in your wishes and desires in your legal documents are then set, and you and your family are protected. It's a huge relief. Most families end up looking like the weight of the world is off of their shoulders after their signing ceremony, which is a treat for all of us when we get to see that. And then we do our favorite aspect of your plan, which is your legacy interview, where we record via video your insights, your values, your stories for the next generation. So again, those things are not lost. Right after your signing ceremony, we start funding your assets so that your plan actually works. We mail and fax any of the things that can be mailed and faxed that can be sent to financial institutions directly. And we prepare instructions for you for any financial institutions that are going to require you to go in person or complete things online. If you're not tech savvy, you can also set up an appointment with our funding assistant who will be able to help you handle funding online if you need help with that. We also handle transferring the deed to your house or any other properties into the name of your trust. So this entire process is about a 4-week process to get your estate plan in place. And we do the heavy lifting all along the way to make this process as efficient and as easy as possible to actually get accomplished, not just talk about getting accomplished, but to actually get accomplished. At your signing ceremony, we also go over our membership program, and that's something you can sign up for if you choose to, where you can keep your plan updated. And we highly recommend doing that to make sure that it's tracking with your life and that those updates get done consistently. So we've talked about a lot of ways estate plans can fail, a lot of risks to bad planning, but the biggest risk really is your family, you procrastinating, and the risk is to your family. Thinking about planning, learning about planning, but never actually getting the proper plan in place that's there to protect your family. And then if something happens and it's too late at that point to fix anything. Our goal is really making that entire process as easy as possible and supporting you in whatever ways we can to keep moving forward towards that goal. To help you overcome that biggest risk of procrastination and to reward you for your time and attention really during this workshop, I do have an offer for you. We call it our golden ticket offer. To be eligible to receive the offer, there are several things you have to do. Number one, you have to attend this workshop, which you've done, so check. You've already completed step one. The next thing is to schedule your legacy planning session with us during this presentation. I'm going to share a link with you now for you to be able to do that. Share. So that you have that. So that should be available. You also have the QR code on the screen. And we have about another 5 minutes left with some Q&A at the end as well. I just sent the link, so there's plenty of opportunity for you to be able to do that. The other thing you would need to do is to be able to complete your legacy questionnaire before your planning session, ideally a week before your planning session, so that the attorney can prepare for your meeting. The questionnaire also helps you get really financially organized, making sure that nothing is lost and preventing your assets from being in that unclaimed funds, making sure that you have that organized list. If you do your questionnaire before your legacy planning session, you don't have to pay the $750 to meet with one of our attorneys. You can get that meeting for free. If you're married and planning together, you also have to attend your appointment together in order to get that $750 waived. We know from experience that you won't be able to relay everything that happens in the legacy planning session to your spouse if they don't attend with you. So if you want that session to be free, you both would need to attend and also attend this workshop, making sure that you either get the recording of the workshop or if you're both here together, that would be perfect. But you complete the questionnaire. One questionnaire is fine for both of you for a joint questionnaire, and then both attend the legacy planning session. If you keep your appointment you also get an additional $250 off of the planning that you might choose to do with us during your legacy planning session. And that discount is good through the week after your legacy planning session. So you have a full week that is good for after the legacy planning session. So if you do all of those things, not only will we waive that $750 legacy planning session fee, we'll credit you $250 towards any planning that you might choose to do with us. So that's our golden ticket to inspire you and encourage you to do what you've intended to do anyway. The link to our calendar, again, is in the chat, and you can use the QR code that I put up on the screen. Pick a time that works for you. Sometimes the calendar does fill up super quickly during these workshops. So if it does, you can also email workshop golden ticket during this presentation to support@adamslawoffice.net. And our estate planning coordinator will contact you as soon as possible to get you scheduled if that link is already filling up. So like I said, my entire practice is built around moving you forward. We want to help you make clear decisions, number one, and not get stuck in procrastination or overwhelm, because that's where a lot of people get stuck in estate planning, putting it off and then never getting it done, and then it's too late. We see it all the time in probate. So this is just one of the ways that we try to help you overcome that procrastination by incentivizing you to book your session during this workshop while the information is fresh in your mind as well, and you're clear on what things that you need to do. It also saves us time from having to follow up with you, quite frankly. So benefits us all to help you continue moving forward to what you've already decided you need to do. So while we have people clicking on links and so forth and getting scheduled, I'll show you an overview of what it looks like in the entire process, our estate planning process starting from this moment. So right now you're in the first box, which is the workshop. You're getting educated about estate planning and what your family needs to do to be better protected. Next, you book your legacy planning session. That's in that second box, so that you move from getting just information to actually taking steps to protect yourself, protect your assets, and your family. After this workshop and after you book your legacy planning session, you'll get an email from us with a link to the legacy questionnaire. That's your homework, the HW, and you're going to complete that right away to get that out of the way. And so that the attorney, again, has plenty of time to be able to review your case, analyze your situation and the law that would apply in your situation before meeting with you. And then in your meeting, we get to deal with the specifics of your family situation and what your goals are and so forth. That's the next phase where we do some homework to prepare for the meeting. And then you have the legacy planning session with the attorney and get super clear on what you need and what you want to have done. You then pick your plan, pay for your plan during the legacy planning session, and then next we prepare your plan and then send you drafts of your plan, which is called, we call it our confirmation of important and missing information, or SIMI. And that is so that we can make sure that we're preparing the documents with correct information for your family, for your agents, for your assets, and so forth. Your second set of drafts from us will be the actual estate planning documents. We send the actual estate planning documents to you to review, to make sure it's saying what you want it to say, doing what you want it to do. So you would receive your trust, your will, your power of attorney, advanced healthcare directive, all of the documents. You then review your drafts and let us know right away if any changes are needed. And then we make those changes. And next is your signing ceremony, the big day. We will review your documents with you that day, sign off on your documents, do your legacy interview, and then start your funding of your assets into the trust. And concluding that whole process with peace of mind, which is usually very visible on our clients, which is, again, such a blessing to be able to bring people to that point and have that in that point of their lives as part of what we get to impact, which is, it's very cool. Okay, so I promised to reserve some time for questions. So let me check out the chat, which I have to bring up to make sure that Okay. Looks like somebody had some problems with the workbook. If you did, email support@adamslawoffice.net and I can email you a copy of the workbook. Let me pull this over here, actually, make it easier to read. Okay. How much does it cost to transfer various assets into the trust? Excellent question. We do not charge a fee to transfer your assets into the trust. We include that in the fee that I quoted you, that $2,500 to $7,500 for the various plan levels. When you're picking your plan, what you're seeing, that fee amount is including all of the things that I just talked about. We will fund the assets for you. Anything we can mail out or fax out, we do. We prepare instructions for you. We fund the deed to your primary residence. The only additional cost would be if you have deeds in multiple states or multiple deeds that you need to do. That is extra. The additional deeds are $750 each to be able to add additional deeds into your trust, but we handle all of that for you. We'll handle preparing the deeds and getting them recorded. Once the estate plan is in place, if I have further questions at any time, is there a cost or fee? And if so, what does that cost? What is that cost or fee? Excellent question again, from Sheila. The membership program is what we recommend for updates. It's really much cheaper to do membership, and throughout the year, you can contact us with any questions that you have. You have free access to us. We have other free things inside of the membership program. But with the membership program, what we do is each year we'll contact you with a summary of your estate plan and ask you, do you have any changes that you need to make to this plan? And you let us know what changes you have, and then you come in and sign off with the notary on any changes that you have. That gets done each and every year that you're in membership. Membership for singles is $450 per year. For couples is $750 per year. If you do an irrevocable legacy plan, we include all of the services we give to you, to your trustee. So that one is $850 per year. If you don't join membership, updates to your plan are just based on our hourly fee, which is $500 per hour. It just depends on the time that it takes to do the update that you're asking for. So it really depends on if the change is going to apply to all your documents, one of your documents, one little thing, a whole bunch of things. So it just depends on that. Are two different trusts required if you own a business? No. If you own a business, you can transfer the interest of your business into the trust. And that is actually really important to do. These are great questions because you want to make sure you have a trustee in place that's going to be able to manage your business if you're incapacitated, or wind your business down if that's necessary after you pass away, or continue your business by hiring managers or doing whatever is needed, or transferring them to your beneficiaries, whatever the thing is. But you want to make sure that person, that successor trustee, is able to do that outside of probate. If your business interests are not owned or assigned to your trust, all of that has to go through probate, and most businesses do not survive that. Okay, let me see. How is payment of the fee done? Can you do installments? Yes, you can. So normally what we do is split the fee in two payments if you're using our preferred payment method of an electronic check or ACH withdrawal. Half of the fee at the planning session, the legacy planning session, and then the balance is paid at the by your signing ceremony. If you're using a credit card, we do the whole amount, the whole fee at the legacy planning session, and you can get all your points and so forth. And we don't have two separate processing fees. Or if you need to, you can also do installment payments on your estate plan. You set up whatever the installment amount is going to be. We then just move your signing date from the normal 4-week time frame to whenever your final payment is going to be. So that's definitely doable. If you need to do installments, we can definitely set that up. Let's see. Sometimes the chat goes too quickly for me to be able to do this. And by the way, if I do not get to your question, let me check time. If I do not get to your question, please make sure you have written your question down so that you can ask it in the legacy planning session to make sure you don't miss anything. Give me Speak a little bit about how grantor. Okay, this is an interesting question. Can you speak a little bit about how grantor uses his or her money while alive? Always been a little unclear about that. So the grantor is the person who creates the estate plan, the trust. So if you're using a revocable trust, the grantor is usually the trustee of that trust. So as the trustee, you have full access to your assets just like you do individually now. So if you, for example, have let's use your primary checking account. For most primary checking accounts, we put a beneficiary designation on that account to the trust so that the primary checking is still in your individual name. You're still the one managing it like you always did. But if something happens to you, it flows into your trust. The reason we do that, number one, is if you have automatic payments set up, automatic deductions set up, all of that, we don't want you to have to redo that. You'll notice on the legacy questionnaire, we ask that question, and that's why we're asking that question. We need to know whether we're doing beneficiary designations or putting it in the name of the trust. All of those funding things are actually super crucial to make sure your plan actually works properly. So using your money is just like using your money now. You do whatever you want to do with it, either as trustee or in your individual name if the trust is beneficiary of the account. Hopefully that answers that question. Does each level include transferring assets, or is the transferring assets at the higher levels? Another great question. Each level includes transferring your assets. One of our plan levels is a will plan in case somebody has no assets that would go through probate. We still offer that will plan, but wills go through probate. Even in those plans, we still help with funding because there are things you can do to shift how things are titled, to avoid as much assets going through the probate process as possible. But again, the will plan is generally for somebody who's literally like just starting out in life. Anything they get in terms of income is coming into the account, going out of the account. They have no real estate, obviously, because that would be going through probate if they used a will. But yeah, the will plan, the revocable trust plan, the irrevocable trust plan, all of our plans include funding. We made a decision a while back to do that so I could sleep at night, and also to just make sure the clients were being served properly, that none of our clients were ending up out there without things funded into their trust. Let's see. I think I answered that one about membership. Okay, here's a good question. If I already have a trust but need minor changes, how much does that cost? So the attorneys and I go back and forth about this particular question. In some cases, we will do amendments to somebody else's trust. What we encounter is trusts that are so bad, doing an amendment to it almost feels like malpractice. So we just will not do the amendment because keeping the trust in place is not a good idea. But if your trust is robust enough, doing what it's supposed to be doing, fully funded, we can potentially do amendments to it. It's based on the hourly fee. Usually the other question that we get kind of related to this is, will we review your already prepared trust that you had prepared somewhere else? And what I have told our estate planning coordinator who handles intake to say to clients who ask this question is, it's generally much cheaper for you to have us redo your estate plan than for you to pay for us to review a trust that you already have a question about. You already have a feeling like it's not correct, it's not functioning properly, it's not working right. Otherwise, why would we be reviewing it? And that feeling is probably based in reality. You know it's not working. So paying us to review it to tell you the same thing you already know is a waste of money. We don't feel good about that. And then we still have to have you get a new trust. You still have to redo the thing that you have in place that's not working. So then you're paying again. So usually if you have that feeling about your estate plan, especially if it's not funded, we should be starting from scratch. We already know our documents are top of the line, state of the art. We keep our documents updated. We keep our documents not just as documents, but we are using these documents in your estate plan when you do your legacy planning session to tailor make your plan to you. So it's not just a form document. So we already know that's going to be at a different level than what 90% of the estate planning attorneys do. So most of the time when we're reviewing plans, we end up saying it's not a good one. Every now and then we'll get a plan that's just out of date. And even then you still have to redo the plan. So it usually ends up being not a good idea to have us review it and then have to tell you you need another one anyway. Let's see. Once the estate plan is in place, for the cost of fee. I went over that. Do we still need? Okay, I knew this question was going to come up because this is a recent law. Can you talk about a transfer on death deed? Do we still need a trust? Excellent question. Yes, you do. All of the things that I went over in the slides about beneficiary designations are the issues with the transfer on death deed. You're creating all of those issues into real estate, not just a bank account. So 100%, the trust is a better vehicle. I call the transfer on death deed. I know why the legislature put it in place, because they're trying to prevent as many assets or as many estates going through probate as they can. But those estates are still going to end up going through probate because they're going to be bank accounts, there's going to be vehicles, all of these other things that the person has not planned for. So I feel like it's kind of dangerous to even encourage it. But also, what you're doing when you're putting the beneficiary designation on there is not solving any of those other issues that we just talked about. It does not solve the Medicaid spend down issue. It does not solve the mismanagement issue of beneficiaries. It doesn't solve the asset protection issue if they're going through a divorce, creditor issue, lawsuit, tax issue, any of these things. At the time they inherit your property, now your property is at risk. The thing that you've left them to try to give them a future, you've now put into the situation that they're in if they're facing anything when they inherit it from you. If that person passes away before you, that asset is now going through probate. If that person ends up having bad habits in the future, they're now inheriting real estate that they're going to either waste or not use properly. Certainly if it's minor, you should not be doing that. And then all of the other issues, all of the things I talked about with joint ownership, all of those things still apply. The trust is the thing that has been developed years and years and years ago, hundreds of years ago, in fact, in Europe, to deal with all of these issues that came up from the traditional estate planning or the DIY type of estate planning where you add beneficiary designations or joint ownership to try to avoid the probate process. It doesn't completely avoid it. So the trust is definitely still recommended. All right, I think I have covered that, and I'm right on time in terms of our end time. So thank you all so much for giving me the opportunity to provide this information to you. We love doing these workshops for the community to make sure people understand what options are out there for estate planning rather than having to end up in the mess. So I really appreciate all of you joining me and being here. And if you have further questions, please be sure to write those down so that you can get them addressed in your legacy planning session with the attorneys. And I think that is it for me. Take you to my final slide. And again, thank you for coming. I hope this information was helpful and really inspires you to begin legacy building, and that Adams Law Office will have the honor of helping you to create that legacy. Thank you so much.